$1.5 billion. That's what his invention was worth. He built it over 20 years, finished it on a drive in his Mercedes, and then his employer took every cent. And a court said that was perfectly legal. And the clause that did it? You've probably already signed one. Evan Brown was a software programmer in Texas, and for 20 years he'd been chasing one idea: a system that could take old mainframe code, the kind that ran on machines the size of refrigerators, and automatically convert it to run on modern computers. He started thinking about it in 1976. By the time he joined a telecom company called DSC Communications in 1987, he'd already been working on the concept for 11 years. On his first day, Brown signed an invention disclosure agreement. Standard stuff. Most people don't even read it. This one had a clause requiring him to hand over any invention in any way connected with any subject matter within the existing or contemplated scope of the company's business. For 9 more years, Brown kept tinkering with his idea on his own time. Then, in April 1996, while driving his Mercedes, the final piece clicked. After 20 years of thinking, he'd cracked it. He estimated the finished system could be worth $1.5 billion. So, he did what most people would do. He told his boss. Brown sent a letter to his supervisor saying he had solved the design elements of the system. That one word, solved, would destroy him. As Brown later explained, the killer was that he used the word solved instead of solving. By writing that he had already solved it, the court would later argue that the work was completed while he was an employee, not before, not on his own time, on theirs. Brown tried to negotiate a deal to share the profits. DSC wanted it all. When Brown refused to hand over the invention, they fired him, and then they sued him. The company was later acquired by Alcatel, the French telecom giant, and Alcatel kept the lawsuit going. 5.5 years of litigation. In 2002, a Texas court sided with Alcatel. The invention disclosure agreement was valid. Brown lost everything. But it got worse. Not only did Brown lose the rights to an invention he valued at $1.5 billion, the court ordered him to pay Alcatel's legal fees, $332,000. He invented something worth a fortune and ended up owing money. Brown said, "Corporations cannot own parts of people. They can't own your brain." The court disagreed. And if you think this is one unlucky guy with one bad contract, it's not even close. Carter Bryant was a product designer at Mattel, the company behind Barbie. One day in 1998, while driving near a high school in Springfield, Missouri, he saw a group of teenagers in hip-hop-inspired fashion. They looked nothing like Barbie. That evening, Bryant went home and started sketching. 4 characters: attitude, edge. He called them the Bratz. Bratz launched in 2001 and became massive, $2 billion in global sales by 2005. They captured 40% of the fashion doll market. Barbie had real competition for the first time in decades. And Mattel was furious. Mattel sued for $500 million, claiming Bryant had created Bratz while employed at Mattel, which meant Mattel owned the idea. And at first, they won. A jury awarded Mattel $100 million, and a judge went even further. He stripped MGA Entertainment of all rights to the Bratz brand entirely. A $2 billion franchise handed to the competition. But then, the appeals court reversed the whole thing, and the reason came down to one word: Bryant's contract with Mattel assigned his inventions, but it didn't specifically assign his ideas. The court ruled that an invention could include an idea, but the contract didn't make that clear enough. One word. That's the difference between keeping a $2 billion brand and losing it. Bryant got lucky on a technicality, but here's what most people don't realize. Most modern contracts have already fixed that gap. The newer versions say inventions, ideas, concepts, discoveries, works of authorship, the whole list. That loophole is closed. This keeps happening. In 2011, the U.S. Supreme Court ruled on Stanford versus Roche. A researcher signed 2 contracts, one with Stanford saying he would agree to assign his inventions, and one with a partner company saying he hereby assigns them. 2 words of difference. The Supreme Court ruled that hereby assign was an immediate transfer of rights. Stanford lost the patent. 7 justices, 2 words, and the inventor had no say in any of it. And here's the part that should worry you. You don't even need to sign a contract. In Tietz versus Chromalloy, a chief engineer developed a new process for jet engine blades. He had no written IP agreement at all. The court ruled that because his employer assigned him to solve that specific problem, an implied contract existed. The company owned it anyway. There is one case where the employee won. Armand Chiavata worked at Ingersoll Rand. His contract had a clause claiming any invention made within 1 year after leaving the company. They fired him. 2 months later, while fixing a light fixture in his house, he got an idea for a new product. Ingersoll Rand said, "That's ours." The New Jersey Supreme Court said no, the clause was too broad. But Chiavata had to fight all the way to the state Supreme Court to prove it. Brown lost. Bryant barely survived. Chiavata won after years in court, but the pattern is the same. One clause buried in your employment contract can decide who owns the most important thing you'll ever create. If you work in tech, you've almost certainly signed one. Google, Apple, most major tech companies have a clause that says anything you invent belongs to them. You sign it on day 1, usually without reading it. It's called a proprietary information and invention assignment agreement, but the name doesn't matter. What matters is the scope. A poorly written one can claim everything you create. Your side project, your open source contributions, the app you're building in your garage at 2 in the morning. And here's what most people don't know. Under US patent law, the default rule is that the inventor owns the invention. The Supreme Court confirmed it. Since 1790, patent rights belong to the person who created the thing. Your employer doesn't automatically own anything. It's the contract that flips that rule. And most employees flip it on their first day without even knowing. Only 11 states in the US have laws that protect employees. California, New York, Illinois, Washington, 11 total. These states say your employer can't claim inventions you developed entirely on your own time, with your own equipment, unrelated to their business. But that leaves 39 states where the contract language is the only thing that matters. And a Texas Law Review article called these clauses what they are: a mortgage on a man's brain. First, read your contract before you sign it. Look for anything called a proprietary information and invention assignment agreement. Watch for phrases like hereby assign, all inventions, or conceived during the term of employment. The broader the language, the more it can take from you. Second, Fill out the prior inventions schedule. Most agreements have an attachment, usually Exhibit A, where you list everything you've already invented before starting the job. This is your proof. If you had a side project before day one, write it down. If the form says none by default, cross it out and attach your own list. Evan Brown's biggest problem was proving his idea came first. Documentation would have changed everything. Third, negotiate. Most companies say the agreement is standard and non-negotiable. In practice, many will carve out specific side projects if you ask. And even if they won't change the contract, get an email from your hiring manager or legal team confirming your project is excluded. That email is real protection. GitHub actually open-sourced a balanced IP agreement that lets employees keep personal projects, and it's worth asking if your company would consider something similar. And know your state's law. New York just passed protections in 2023, New Jersey in 2018. If you're in one of those 11 states, your employer can't claim what you built on your own time with your own tools. If you're not, the contract is all that stands between you and losing everything. Evan Brown spent 20 years building something extraordinary. One paragraph in a contract he signed on his first day of work took it all. He said, "Corporations can't own your brain, but one clause can own everything your brain creates." Pact Alert tracks every obligation in your contracts, the deadlines, the clauses, the things that matter before it's too late, because the fine print doesn't care whether you read it. Would you still sign the same contract you signed on day one?